with the chapter, and 3 provides that those rights are subject only to the limitations contemplated by the Constitution. Now, in developing that issue, we have what we call enumerated and unenumerated rights. And it could seem that what Article 19.3b states or provides for are what we would refer to as unenumerated rights. Now, while enumerated rights are clearly written, the unenumerated ones are inferred. So that the concept is that there is a limited list of rights in a constitution that does not mean that fundamental rights do not exist. So the first question is as follows. Are there rights that you would say that are fundamental and are not contained in Chapter 4 of the Bill of Rights, but they are unenumerated and you can infer them? And if so, if you probably can list maybe 4 or 5.
Okay. Commissioner, I'm not sure I know I have an answer to the point you made about the enumeration. I'm not aware whether there is anywhere where they are listed, other than in the Constitution, of course, which I'm aware of. But I don't know whether they are somewhere else tabulated. Commissioners, I will pray to probably refer to the experiences I have. Some of the rights that I know are internationally recognized but are not captured in the Constitution is, for instance, against genocide. I am fairly sure it is not in the Constitution in the word genocide. I know there are issues of human dignity, human rights, against servitude and all that. But I think genocide as a crime is not there. And I'm borrowing from the International Criminal, the ICC statute. And I'm referring to the ICC Act because Kenya is a signatory, which in effect then, and most of the world countries are signatories, which then means it is a recognized right. So genocide, war crimes, acts of aggression. Others that come to my mind, and they do not necessarily even relate to Kenya, is apartheid. I think there is generally condemnation of conduct that amounts to apartheid, and I think that could be one of the rights that you could incorporate there. The upheavals in West Africa resulted also in warrants and summons on issues of damage to World Heritage Sites. And so I think UNESCO protected locations, or rather damage to World Heritage locations are also a crime. Commissioner, I hope I've managed to make 5. I'm not sure if I have.
Okay. Now I want to go to Article 45 just to explore that topic.
Yes. So
Article 45 of the Constitution provides that the family is the natural and fundamental unit of the society and the necessary basis of social order, and shall enjoy the recognition and protection of the state. And more importantly, Article 45(2) provides that every adult has a right to marry a person of the opposite sex on free consent of the parties. Now, when you read Article 27 on equality and freedom from discrimination, this is now the equality clause. It provides that every person is equal before the law and has a right and equal protection and equal protection and equal benefit of the law. And then there is another important article provides that the state shall not discriminate directly or indirectly against any person status leave. In the first draft of the Constitution actually provided for discrimination against sexual orientation, but subsequently in the discussions that followed and the final draft excluded that reference. Now, if again you read Article 2(6) of the Constitution, it provides that any treaty or convention ratified by Kenya shall form part of Kenyan law under this Constitution. So I wanted to ask a question using that context. Now, Article 16 of CEDAW, the Convention Against Discrimination of Women, provides that a woman has a right to choose their partner. And the definition in Article 16 of CEDAW is different from the one that is found in 45. So the question is, if a party comes to court and pursues an argument that that article would allow maybe a same-sex marriage because it's a convention that forms part of Kenyan law, what would your view be about it? And would that be then what we started developing about an unenumerated right?
I can answer?
Yes.
Okay. So first of all, let me just add one more in the list I've given. I've just remembered in the course of you inviting me to Article 45, I have remembered that Kenya now acknowledges for a fact that intersex people are entitled to rights.
Yes.
And that's not one of the rights of intersex and transgender. And I thought, even to the extent it is not enumerated, it is a consideration. I'm just concerned at what it says in 19.3b, that to the extent that it is not inconsistent with this chapter 4. Now, just on that issue of transgender and intersex still, I have sometimes wondered whether the Supreme Court should be asked to determine whether the Constitution on its face, looking at it on its face, is wrong. Because at 45.2, I haven't answered your question, I know, but I'm just laying the ground.
Yes.
45.2 says every adult has the right to marry a person of the opposite sex. Now, what happens to the transgender and intersex people in Kenya whose existence we have acknowledged? Have they in effect been excluded by the Constitution? And probably more pointedly, and I think now this comes to the question you're asking me, is if two intersex or two transgender people come and say they want to marry, and the courts have determined that they are entitled to rights, are they then to be denied the right to marry using Article 45.2? And could it be that the drafters of the Constitution then were mistaken in the wording they have used in 2 because they have in effect discriminated? And further still, whether then the Constitution on its face is wrong and discriminatory. Now, to the question you've asked whether what I would do if I had two same-sex individuals seeking permission to get married to each other. To the extent to which there exists that clause 45.2 saying the limit of people who can marry each other of opposite sex, I would say it is not possible. However, Commissioner, it is an issue I've looked at because I had, in my previous life, I had been asked to consider an argument on this. I have sometimes wondered, Commissioners, whether Article 45 can be read to represent two scenarios. The first scenario is that one limited only to paragraph 45.2, being two adults needing to marry, in contradistinction from a situation where the heading of that Article 45 is headed family. And then one says family is the natural and fundamental unit of society. Whether it is possible to deny permission for marriage, but the Constitution inherently acknowledges that you can have a family of same sex. That would be my contention, that for purposes of marriage, probably as a judge, I would say the law is clearly prohibitive. But then I would wonder then whether the law seemingly at clause 40, so the only exclusion is 45.2. 45.1, 1 and 3 and 4 seem to accommodate existence of a family. And so if it is possible to argue that there is a difference between a marriage and a family, then it should be possible also to say that there is almost a permissive extent to which the Constitution allows a family constituted of people of same gender. Of course, I'm very much alive that I am a candidate. I know it's a very unpopular argument, but I'm just making it as a legal argument. I'm not making it as a question of my position. I need to clarify that. The second limb of your question was whether then you could say that Article 16 of the Convention on Women's Rights, I am not very familiar with that convention, whether that Article 16 is one of those unenumerated rights. I think the Article 19 that you had invited me to was very explicit that they are tenable to the extent to which they are not inconsistent with the Constitution. So if the question was whether or not they can get married, I would say it is not one of those rights that are protected. But if the argument is that we want to be recognized as a family, then I think the matrix of the issue would be completely different. Probably then there would be an argument around it, Commissioner.
Okay.
The question was very long. I have tried as much as possible to answer it. I don't know if I've answered it.
Yes. So I tried to set the context because sometimes there are hard questions that are presented before the court and that the court should answer. Now I want you to take to Article 49 on freedom and security of a person.
Yes.
So Article 49 provides that every person has the right to freedom and security of the person, which includes the right not to be, and for purposes of my question, is D, subjected to torture in any manner, whether physical or psychological. So, physical torture is fairly, something, it's discernible.
Yes.
But psychological torture might not be, immediately discernible. So you have, and this possibly we practice it when we were younger, where we were, as children, we did not have a choice to the oath of allegiance. I pledge my allegiance to the President and the Republic of Kenya. You remember that?
Yes.
Or salutation of the flag.
Yes.
Now, would you say that forcing children, to do oaths of allegiance or to salute to the flag, without having the choice on participating in those activities, would amount to being subjected to torture, whether physical or psychological, because it's not a choice that you have, particularly if you're in school. I don't know whether it happens right now, where you are told, salute to the flag, or it's at 6 p.m. the flag is about to be lowered, stand up and be at attention, or do the loyalty pledge.
Okay, so can I answer?
Yes.
My answer would be, I understand your question to be particularly in respect to the flag. You didn't say what flag, but I assume it would be the national flag.
Yes.
You also said pledge. I assume it is pledged to the country rather than to an individual, or to any religion. To the extent, therefore, that you are dealing with national symbols and national concern, I would think it is more of patriotism than a question of torture. That's one. Number two, I would say, since your question is very carefully cross-referenced with children, that children being people who are being molded, it is right that they should be subjected to develop a sense of patriotism and loyalty, and I wouldn't see anything wrong in subjecting the children to appreciate the importance of patriotism and loyalty as they grow. And lastly, you tie your question with the question of torture, both physical and psychological. My understanding would be that torture is a relevant part if you intend to extract something out of it. In the situation of the children, I think it's just teaching them where priority, where importance, where values exist. It wouldn't seem to me like anything is being extorted out of the children. They are not being asked to make any confession. They are not being asked to sign off any rights. They are not being asked to surrender anything or to give anything. And to the extent, therefore, that it is part of education and development of the children, I would contend that it is a legitimate conduct.
Okay. And lastly, if you look at Section 3 of the Supreme Court Act, provides for the object of the Act and makes further provisions with respect to the operation of the Supreme Court and its final judicial.
Choose from thousands of realistic voices to use in your content. Change the way you record podcasts, voiceovers, and branded content with the #1 AI-powered voice-generating technology. Stop searching for the perfect voice and stop wasting time re-recording take after take. Try 11 Labs for free and start elevating your content today.
Or it has infused these constitutional principles and created sort of a Kenyan context interpretation of the law. And I get this from what Justice Mutunga used to say, that we should develop jurisprudence that is indigenous.
Okay, so I will answer the question in terms of what indigenous jurisprudence and principles of law have been developed by Kenya, and with reference to your question, particularly by the Supreme Court. I think in the recent past, the Supreme Court has made a determination on the question of matrimonial property. And in it, I think it is an indigenous contention that contribution for purposes of the rights of a spouse can be gauged, not limitedly to financial contribution. It could very well be in kind, family upkeep, taking care of the children. And I think that's an indigenous contention that contribution is not limited to financial contribution. I think that one. The other one, although I can't say for us absolutely that it is, it has been determined by the Supreme Court, I think is the issue of trust on land. Being that where you have a family member being registered in the course of adjudication and other types of registration, being registered as the owner of the land, it shouldn't be perceived as if that is the only owner of the land. It should be treated as a trust on behalf of the family, on behalf of the other family members, and that it is being held by the person whose name is registered in trust for the rest. The other one is probably also trust in relation to matrimonial property. That where you have one spouse is...
Thank you. All right. Thank you. Thank you. All right. Thank you. Thank you. All right. Thank you. Thank you, CJ. That's all.
Thank you.
Thank you very much. We now move on.
For example, or for instance, there is a pervasive understanding of what constitutes public interest. And rarely do courts differ on what constitutes public interest. But we cannot say the same of general public importance. So as you answer, you may kindly also tell us whether there is a difference between public interest and general public importance, and whether or not there is a need for jurisprudential coherence and guidance on the same.
As usual, AG asking me the toughest question. So let me start first of all by saying, I would have thought the Supreme Court, because it has reiterated this, I know every other person wants a chance at the Supreme Court, and so there have been so many applications to the Supreme Court. And I think the Supreme Court has been very consistent in saying that for general public importance, the criteria is number one, that the issue you are seeking the court's attention for should transcend your personal dispute and should be a novel issue that needs resolution and will be used by other parties. And thirdly, that it should have escalated from the courts below to the point of the Supreme Court for determination, that you do not jump onto the Supreme Court and ask them for a determination when it has not graduated and escalated through the courts below. Now, you are then, I also wondered whether your question was also whether the court has settled jurisprudence on whether they can consider interlocutory applications. And my reading of it is that initially the Supreme Court had said we will not deal with any interlocutory application. We will only determine when it has yielded a judgment. But then with time, they have put some riders where they have allowed interlocutory applications, even when the substantive hearing has not been determined. Now, on the specific question of public interest and public importance, that was the question, Honorable AG. Public interest and public importance.
Whether there is a difference in definition or understanding.
I would contend that public interest and public importance is one and the same thing, especially for purposes of the determination of the question for the Supreme Court of a matter of general public importance, because it would be both in the interest of the public and of importance to the public, whichever question they have to wrestle with. Would be one that has been distilled as being one that the public is interested in and is very important for the public. I know the concurrent argument between the competition between public interest and I think national interest, but that's not your question. But I would say, in answer to your question directly, for purposes of Supreme Court. For purposes of Supreme Court's jurisdiction on a matter of general public importance, I think I would deem and consider any matter that is of public interest and public importance to be one and the same for purposes of the court's consideration. And I would say the court has obligation to consider them, whether it amounts to being a matter of public interest or it amounts to a matter of public importance.
Okay, and finally,
yes.
Do you think there are instances or cases where the Supreme Court has made a mistake? And if so, would they have done anything better? If you can identify one or two. I'm not saying they have. I'm asking you whether you think there are cases where they have made a mistake, and if so, would they have done better?
Okay. It is an unfair question because I'm a candidate, but let me answer it all the same. Murwatetu 1, I think, could have been done differently. Because been done differently. Because for contention on human rights concerns. And my understanding of what Martha Karua had taken to the East African Court of Justice was to say that the totality of the way the court handled my matter, the totality of the way the law is structured, is such that I have been victimized, because I've been victimized by being placed in a situation where time has expired before I've indicated my right, and therefore my rights have been violated. I thought the Supreme Court, instead of dealing with that narrow question of whether or not the East African Court had, as if the East African Court had evaluated the merits of the Kenyan courts. And I thought that Karua's case was just limitedly saying the totality by reasons of actions and omissions in the statutes, in the Constitution, in the handling of the matter by the courts is such that my rights have been violated. And so should I be compensated? But instead, the decision that came out.
Thank you. Maybe just a follow-up question on Murwatetu.
But may I say also, Honorable Attorney General, this is the second time you're asking me that question, because the last time you can decide on matters that belong to domestic jurisdiction. I answered it, and I think correctly, but then I didn't have this authority. I saw it much later, and I wished you could have answered me. I'm glad you gave me another chance to answer it more.
Okay, thank you. But a final question about Murwatetu 1.
Yes.
What is your view about the operations of a statute, retrospective operation of a statute that is declared unconstitutional? And I think that is one of the issues that should have been dealt with in Murwatetu 1. When a provision was declared to be unconstitutional, yes, or that the courts did not have discretion in murder cases, and therefore the issue of discretion was created. Now the challenge was it going to apply retrospectively? And from the understanding of the practitioners then, they started applying it retrospectively, and therefore the challenges in its application. Especially in criminal law.
So let me say, my understanding of retrospectivity of law is that retrospectively. However, there are instances when the law itself allows for that retrospectivity. And so, except where it has been directly addressed as having to operate retrospectively, I would contend that a law should not operate retrospectively. Now, in Murwatetu, I don't think the question was the retrospectivity of the law, because it was a question of a finding. It was just a saying, determine whether this thing is black or green. And when the court then said, mandatory death sentence is wrong, is as constitutional impropriety, when it was made, when a finding was made to that effect, the consequences, the Supreme Court was not necessarily saying go and apply it retrospectively. It was just saying, the way I would understand is that nobody had brought this thing earlier, but now that it has been brought, we are making this finding today on the 28th of April. How then it will roll out is a question. It is. I don't think it is part of their mindset that we intend to have it to apply retrospectively. Of course, I appreciate that orders were made for reconsideration of sentences, but I think it doesn't quite fall on the four corners of the law of retrospectivity, because the law of retrospectivity refers to the enactment of a law. What the Supreme Court was doing was a question of making a finding on the face of the provision as to whether it was right or wrong, regardless of the timing, whether so much time had passed or not.
Thank you.
Thank you.
Thank you.
Judge. Once again, welcome. Let me take you back to the discussion of GPI under Article 163(4)(b). And a number of decisions from the Apex Court have settled the position that conflicting decisions can be considered as matters of general public importance, and upon certification, these matters can be rightly considered by the Supreme Court position, which I totally agree with. Now, or the Supreme Court. If it's done by the Court of Appeal, it can be reviewed by the Supreme Court. Appeal from a small claims court, no room to go to the Court of Appeal. And courts have decisively said you cannot assume jurisdiction, so there's no way you can go to the Court of Appeal. And as a result of that provision, we have seen so many conflicting decisions in the High Court from several issues of law that, in as far as we know, the window for resolution of conflicting decisions is opened before the Apex Court, from the High Court, so to say, to the Apex Court. Now, the question is, do you think, in consideration of public interest, the Supreme Court, for purposes of resolving conflicting decisions, maybe in the conflicting decisions, maybe in the High Court or tribunals, which the High Court or tribunals, which exercise final appellate, the Supreme Court, and deal with them?
Thank you, my Lord. I think from my reading, the Supreme Court has but in a normal litigation, then you can't enter the Supreme Court without passing through the Court of Appeal. I wasn't sure I got your question because you started by saying small claims court, and I saw you almost said MCS also, because I think also MCS enter the High Court. They can't go beyond there. And the question you're asking is where there are conflicting decisions, whether they should go to the Supreme Court. And just for clarification, very kindly, Commissioner, are you limiting your question to the conflicting decisions in small claims issues, or generally on issues that cannot escalate beyond High Court?
Let's be general.
Okay.
I brought in the issue of small claims as an example.
Okay.
But it's a general question.
Thank you very much. Yeah, of course, the other example would be the MCS. This is the way I would answer, my Lord, that I would think the Supreme Court would have jurisdiction if there is a genuine matter of general public importance in any of those issues, being a real identifiable issue that they need to resolve rather than a question of merits. And if it were to be the case, as you say, that there is concern that there is strangling of some causes not to go beyond High Court, I would see a petition being framed to cover, including the concern you have, that one, either the question arising from small claims courts is this, it is a matter of general public importance, or this issue in the MCS elections is of general public importance, and ask the High Court to determine whether they are substantive enough and to apply their minds. So there would be then a determination on two things: that it warrants it, and one of the parties is aggrieved, then leave as a matter of constitutional right to escalate it to the Court of Appeal and to Supreme Court. So that then for me it's a question of how it is framed. It needs all the issues just need to be placed on the top of small claims. It doesn't matter that it is a matter of small claims. It doesn't matter that the policy for small claims is finality of litigation. What matters is that if there emerge a very significant point that needs consideration by courts, and then I think it could still escalate. Depending on how it is framed.
Now, Judge, if I get you right for clarity, even after you are satisfied that is an important question which needs consideration by the SCOC, you will give more credit to the process and maintain that you can only frog from High Court to the Court of Appeal. To the Supreme Court. The substance of what? Because that may go contra 159 article.
Okay, first of all, let me just answer. Your question directly considered it. You can't fly it over to the Supreme. Yes.
But this is a matter which does not need any clarification, any further clarification. The Supreme Court has already said, if there is an issue of conflicting decisions, that's a matter of GPI. The issue is settled, it's clear. Say.
Yes, my lord. I think there are still some cures. Issue of the other one was the issue of arbitration. So that it is not good enough to just say one High Court judge says this, the other High Court judge says this, so there is conflicting, let's rush. Or that one bench of the Court of Appeal says this, the other one. I think there is still that aspect of saying, let's now constitute a bench of, say, five. Even in terms of policy, it would be disadvantageous if somebody just walks to the door of the Supreme Court and says, I have these two decisions, please decide for me, before it escalates. So if you have a bench which has been decided by 333 in Court of Appeal, and you constitute a bench of, say, 7 or 9, the likelihood is that the assembly of those minds probably will resolve the issue and harmonize it. And if there is no agreement, it can still escalate, go over directly to the Supreme Court. Directly to the Supreme Court.
Told. It's already clear that conflicting decisions are matters of general public importance, but we can hold it at that. Let's get to elections. We are some few months into general elections.
Yes, my lord.
And do you think, Judge, that there's a difference between general elections, fresh elections? And a runoff.
General election, fresh elections, and
a runoff.
50+1 in a presidential election, in which case then the top two candidates would go into runoff. General elections is the standard cycle of 5 years elections. And fresh elections is where elections have been nullified and parties have to go back, or rather, constituent entity, constituency.
I want us to consider an issue. I believe it has not arisen yet, but it can arise. And let's take a walk to a fresh election, and let's start from point where a petition challenging a presidential election is filed in the Supreme Court. Judge? Yes. Now, let us take it this way. A petition is filed before the Supreme Court challenging the election of a president. And a candidate, an unsuccessful candidate, decides not to file a petition, is allowed to join in these proceedings, in this petition, as an interested party. An interested party has identifiable stake in this matter and has the right to file and in this petition, the election has to be nullified, and once nullified, the position of this candidate is clear, that I want to take part. He has not acquiesced his or her position in that. He has stated very, very clearly in pleadings that if the petition succeeds, I also want to run. And the petitioner and the reasoning has been the rest of the candidates, as long as they have not shown any interest, they should not take part, which I agree. But this is a situation whereby this party who has been allowed by the court to come in as an interested party has expressly stated that the party be able to take part in that fresh election.
Thank you, my lord, for the question. We need to. Okay, so your question, as is the nature of always candidate. But I want to,
the petitioner must be
and it is easier
candidate.
for me to answer the question if you don't. I don't have an answer to that question. Interested litigant, and you are declaring that parties must go back for fresh elections. There has to be other candidates. So I would say in the scenario you've made, the candidates, so long as a person was a candidate in the elections leading to the nullification, they are eligible to participate, unless there is a specific reason why not.
Let me get to
Yes.
that, Judge.
Yes, sir.
You're saying in a fresh election,
Yes. It depends on the nature of...
no, we are a case premised on the petitioner being a candidate.
Okay.
And the court said it is only the candidate who is the petitioner, and the Supreme Court says the other candidates should not participate is they have not taken any active step in expressing their desire to run in the fresh election.
Yeah.
But this is an interested party who has said, I'm interested. I filed my paper, I support this petition. And if it goes through and a fresh election is called, I'm interested to run. So they cannot be said to have exercised their position. They have stated clearly that I need to take part in the fresh.
So, my lord, I would think that if an interested party has come and said, because an decision.
Yes.
If he is a significant player and it's obvious that he's a significant player because from your illustration he was a candidate,
Yes.
then it is my view that he is eligible to participate in the elections. Because look at a scenario where you have 5 presidential candidates, and when you cascade votes, probably the one who has come to court was the one who got the least votes. And the Supreme Court then says the people who are going to participate are only the petitioner and the if he is a significant player and it's obvious that he's a significant player because from your illustration he was a candidate,
Yes.
then it is my view that he is eligible to participate in the elections. Because look at a scenario where you have 5 presidential candidates, and when you cascade votes, probably the one who has come to court was the one who got the least votes. And the Supreme Court then says the people who are going to participate are only the petitioner and the president-elect, not petition what his takes are, what he considers to be his rights. And considering that it is a question of democracy and representation, I would take the view that an interested party who has made that expression should be allowed to participate in the elections. And I'm comforted by the fact that the point you're making has not been quite directly dealt with, being the question of whether an interested party who comes and says, I want to participate, my explanation for not having, my view is that if he should be allowed to participate. Thank you, too, my lord.
I believe that should be the position, looking at the issue of access to justice, limiting costs, and many other parameters. Thank you for
Thank you.
this rather long engagement. I wish you the best.
Thank you very much, ma'am.
Thank you, Commissioner Ngutia.
Thank you, Chair. Good afternoon once again, my Lord.
Good afternoon.
It's been a long day so far.
It's okay. It's okay.
Yeah, they say Kenyans know the Supreme Court to be the court that only deals with presidential petitions. So I understand why Judge Murima had to take a lot of that time. So, Judge, you did submit Court and High Court on matters touching land, criminal case, arbitral award, and a constitutional petition appeal. And looking at the ICC matter, where you sub the no case to answer principle within the ICC framework vis-a-vis common law jurisdiction, I find the arguments novel, so I commend you. Have you since delivered any decision at the Court of Appeal or decisions?
Yes, I have.
Okay.
Yes.
Of elections, because the Supreme Court does so many other things beside the elections which Kenyans are usually keen on. A key strength in arbitration is finality, and that is why you find most laws for this fundamental principle. In the New to Aggravate case, the Supreme Court was confronted with what is described as question of considerable public importance touching on the interface between arbitration of the Arbitration Act, is silent on whether an appeal should lie to the Court of Appeal, and this is what it held in part. Allow me to read. An appeal may be allowed in very limited circumstances where a manifestly strong decision was made, specifically where the High Court, in setting aside an arbitral award, has stepped outside the grounds set out in Section 35 of the Act to either of the parties. So how would you describe the reasoning of the court by creating this exceptional circumstance vis-a-vis the general principle of finality in arbitration? Was the court trying to cure any lacuna in the Arbitration Act, or did it risk undermining the fundamental principle on limited court intervention in arbitration? Maybe you can give your explanation to your responses.
Thank you, Commissioner. Yes, indeed, in that case of New to, my recollection of reading it is that one of the issues the court had, so the court was dealing with about 4 issues. The first one was whether the court can infer existence of an option to appeal when, I think it is Section 35, is silent, on whether a party who has gone to court for adoption of an award can appeal to the Court of Appeal. And so the question was just very directly whether, in the absence of clarity, in the absence of a direct statement on whether or not there is right of appeal or not, the Supreme Court thought that such an option to appeal could obtain. And reading that judgment, my understanding was that then the court was wrestling with a competition between 2 issues. One is the right of any litigant to a fair hearing, which is a constitutional right, and on the one hand, by the party who wants to appeal. The one party who wants to appeal saying, my rights to fair hearing have been violated, I need an opportunity to ventilate my case. Vis-a-vis the counter arguments from the other side saying that the policy and intention of arbitration clause is to achieve finality and sooner resolution of disputes. And in some, my understanding of how they arrived at its decision is to balance those two rights. One is the right to be heard and right to challenge a situation where the decision of the High Court is so manifestly wrong on its face, vis-a-vis the desired intention of the two parties that there should be finality. And as a consequence of balancing those two interests, then the Supreme Court said with the way the High Court has dealt with the adoption of the award. And so that's why it is restricted, and that's why to my mind it requires leave, because that leave stage is where the court then will see if we list.
So according to it, does not in any way undermine the statutory design of that particular part. And number two, the case of Mitubel Welfare Society versus Kenya Airports Authority. Structural interdicts are recognized reliefs in human rights litigation, and particularly when it comes to enforcement of social economic rights such as housing. In this particular court, in this particular matter, the Court of First Instance had issued structural interdicts. So the Supreme Court affirmed that indeed they are applicable in Kenya. However, sometimes this year, there is the Omtata Tribunal's case. I think it was Omtata versus the National Assembly, where the court in the first instance had issued a structural interdict directing the National Assembly to come up with a tribunal's bill given against Parliament, and it held that in part structural remedies must remain exceptional, proportionate, realistic, and restrained, and that judicial intervention in legislative process is justified only in the clearest of cases. So it appears there are different standards. The Supreme Court has of cases. So it appears there are different standards. The Supreme Court has
Commissioner.
Good afternoon, Omwanzo Mbati, karibu.
Thank you, Commissioner.
Good afternoon, Wakili. Anthony Mrima, you're most welcome.
Thank you, my lord.
Good afternoon. My name is Olwande Evelyn.